So the good news is the recent passing of the Probate Law, AB 2016, will actually help avoid long delays and probate court as well as attorney fees. This new law will actually streamline the process for the probate and those that qualify. Now, I will say that this new law will not apply to everyone, but we'll cover just who and how this may be helpful if you do qualify. Now, of course, even if you don't qualify, I will share with you just how to avoid probate completely by the end of the video. Now, I'm Powell, a local real estate agent serving Ventura and the surrounding communities. So if you want to stay up to date on all things real estate for Ventura and the surrounding area, suggest hitting the subscribe, like, and bell icon to be notified of future content. Now, today's video is for educational purposes only and should not be a substitute for professional advice. So always consult the appropriate professional for your given situation. Under the previous probate law, any summary procedures can only be used if the value of the decedent's entire estate does not exceed $184,500, which excluded quite a few. The new law provides up to $750,000 for the decedent's primary residence, plus $184,500 for personal property. That actually may pass through the summary procedures. So that equates to $934,500 in total between real and personal property, which obviously is a substantial increase. Now, the other substantial benefit with this is time. The full probate process can take anywhere from 9 to 10 months, and that's if there's no disputes and no issues. Now, I've seen properties tied up for years over disputes. So while the new law doesn't eliminate probate, it does introduce new procedures and thresholds for small estates valued up to $750,000 without having to do the full probate. So the simplified petition process for real property just means that the process will be much faster than the full probate process. Now, while AB 2016 does mandate notices to all heirs and the devisees, which could potentially in itself lead to more disputes and possibly still require a full probate and with the issuance of letters. So hopefully that doesn't happen. So let's review the three-pronged test to determine if one qualifies for the simplified probate process. The first is the deceased must have passed away on or after April 1st, 2025. And the second is the decedent's property must be their primary residence. So if it was a rental property or a second home, then it would not qualify for the streamlined process. And third is, again, the value of the house on the date of death must be $750,000 or less. Now, in order to get a court valuation of the house, a probate referee is typically hired to provide an appraisal on the property. So if all three of these requirements are met, well, then you potentially would qualify for this law. Now, before you get too excited, this doesn't mean obviously you can avoid probate court, but it does mean that it will take less time. And as I mentioned earlier, if there are disputes, then it may require a full probate. You may be wondering, if I qualify, do I even need to hire an attorney? Well, you can opt to go pro per, which means you can navigate the probate process without the assistance of an attorney. And the Ventura County Superior Court does offer resources to assist with pro per probate. So while it's possible to navigate the process and filings yourself, hiring a probate attorney can make this process less stressful, easier, and faster, and potentially avoid disputes. So now, given our current median sold price of $880,000, obviously not everyone will qualify for this streamlined process due to property values. Additionally, some of you may be wondering even if I should consider setting up a trust if your home is worth less than $750,000. Well, a couple things to be aware of. One is that we have seen property values nearly double every 10 to 15 years. And the other important issue is that AB 2016 doesn't completely avoid probate, so there are still going to be the cost of attorney fees, court fees, and some time requirements. On the other hand, if you want to avoid probate altogether, then set up a trust. And once a trust is set up in place, the successor trustee can step in immediately upon the decedent's death and act as the new owner to either keep, sell, or rent out the property without the additional expense of court fees, attorney fees. Additionally, a trust will also avoid probate for rental properties and second homes, which AB 2016 won't cover. And a trust will also have healthcare directives and asset protections that your legal professional can advise you on. So, for most homeowners, the best option is still to set up a trust. It will make it much easier and less expensive for your heirs. All right, if you enjoyed today's video, please give it a thumbs up. Thanks.